Firstly, welcome and to everyone across a wide range of sectors who are joining us this afternoon, particularly as everyone has a lot of other demands on their time at the moment. And if other commitments do crop up during this webinar, then rest assured you can drag yourselves away because this is being recorded, and in due course this recording and the slides that accompany the webinar will be sent out to anyone who's signed up for it. I'm sorry that there isn't any technical support, but that just emphasises the fact that it's being recorded and it will be sent to you. So if for any reason your connection drops out or whatever, then don't worry, you'll be able to see this, as I say, perhaps next week, in between everything else. So I'm delighted to be chairing this evening a fascinating topic with an array of professionals and experts in their field alongside me today. And I'm Helen Curtis. I'm going to start by just going through a few of the key principles, a member of the Court Protection Mental Health team here and a mediator. Then we'll hear from Bethan Harris and Tim Baldwin, public lawyers with their expertise in community care and housing law, followed by Ollie Percy in the jurisdiction of the Special Educational Needs and Disability Tribunal, and then Emma Fitzsimmons dealing with immigration and asylum. So without further ado, I'm going to start, if I can share the screen and find the slides. Hopefully that will work. And here we are. A few general introductory principles. A child or a protected party may only conduct proceedings by a litigation friend. It therefore follows that any step that's taken before a child or a protected party has a litigation friend shall be of no effect unless the court orders otherwise. So if you have a concern that a party may lack capacity to litigate, don't ignore that concern. The court has got a power to appoint a litigation friend and does so ordinarily with evidence. The evidence can be in a standard form. Many of you will have seen a certificate of capacity, or it could be a medical report. The few guiding principles, if you like, into which the specialisms from my colleagues will slot into in due course. There's a presumption in favour of capacity. It's contained within the Mental Capacity Act 2005, and all practical support must be given to the protected party during any assessment. So in that case, it's not a question of, as it were, testing the person whose capacity is in question, putting them through their paces without any support or any simplification of language or anything like that. They must be given support for that assessment to be carried out. The burden of proof's on the person who asserts there is a lack of capacity in providing the evidence to say so. And it's a question that's not considered in the abstract. It's not a question out there. It's necessary to ask whether this party has the capacity to litigate in relation to this particular application or these particular proceedings, not a general question. There are two guiding cases that you've seen there in the slides, Masterman-Lister versus Bruton & Co., Sane versus Jewell and another. Court of Appeal decision, which was confirmed in the Supreme Court in Dunhill and Bergen. I'll come back to those in a moment. The test which was set out by Lord Justice Chadwick in the Court of Appeal is whether the party to the legal proceedings is capable of understanding, with the assistance of such proper explanation from legal advisors and experts in other disciplines as the case may require, the issues on which his consent or decision is likely to be necessary in the course of those proceedings. If he has capacity to understand that which he needs to understand in order to pursue or defend a claim, I can see no reason why the law, whether substantive or procedural, should require the interposition of an ex-friend or guardian ad litem, now a litigation friend. And obviously, conversely, if he or she does not have that capacity, is not capable of understanding those issues, then there is a requirement for a litigation friend. Oops, sorry. So the test is contained within sections 2 and 3 of the Mental Capacity Act 2005. And in terms of section 2, the focus is on the impairment or disturbance in the functioning of the mind or brain. Sometimes that lends itself to what's called a diagnostic test. There may be a diagnosis, maybe learning disability, it may be paranoid schizophrenia, it may be a number of different things, but essentially it doesn't have to fall into a particular diagnosis, but there has to be an impairment or disturbance in the functioning of the mind or brain. And I've set out the whole section there so it can be read as a whole, but essentially, when we come to look at how this happens in practice, what's being looked at is what's called the functional test, which is the ability or inability to make decisions. The person is not capable of making a decision. Looking at this, if they fail, if they're not capable of understanding information that's relevant to the decision, to retain that information, and then to use or weigh that information as part of the process of making the decision. So the relevant information has to be identified in practice. The person, the party, protected party, has to be provided with the relevant information about the case, about the proceedings, and then they have to be assessed whether they understand this relevant information. So there may be some questions around that to test this party's capability of understanding, their capacity. Do you have a solicitor? What is his or her role? What do you understand about the choice that the court could make in your case, in these proceedings? What are you asking the court to do? What are the other people in the court? What are they going to ask the court to do? And in that, there will demonstrably be answers sometimes, which in whole or in part are a complete answer. And sometimes there won't be. This is part of the assessment process, usually conducted can be by a solicitor, but the evidence often before the court is in some form of medical certificate or medical report. And the next feature of assessing whether a protected party has capacity is whether they can retain that information. So they may, with some support, be able to answer some of those questions, but then sometime later, maybe 10, 15 minutes later, they may be asked, well, so what is the case about, or what is it that the other party wants to ask the court to do? And they may not be able to remember that. And then the using and weighing of this relevant information in order to make a decision. So can this person use and weigh that relevant information to inform their decision about something, a decision, an agreement to a course of action within the litigation, or an assertion of a decision not to do something in the course of the litigation? Lady Hale used as the phrase twists and turns in the Dunhill and Bergen case, but that using and weighing is critical in the course of making decisions about litigation. There are discrete areas within litigation. Sometimes, certainly in the Court of Protection, there's a distinction between the underlying decision, whether or not to live in a particular place, and that's distinct from the capacity to challenge a decision about where to live in a particular place. And so it's important for capacity to litigate to see the proceedings as a whole, because there's a whole array of decisions contained within capacity to litigate, which you're going to hear more about in a moment. If it's determined on this assessment that this protected party cannot understand the relevant information or remember it or use and weigh it to make decisions about the conduct of these proceedings, then there is the appointment of the litigation friend. And it may well be that more is said about this in this evening. But effectively, as you may anticipate, the litigation friend has to be suitably appointed and mustn't obviously act contrary to the interests of the protected party. And they remain in place until they're discharged, either by the court or because they express a need to cease to, consent to act, or something like that. And who can be a litigation friend? It can often be a family member, it can be a friend. The litigation friend, potentially of first choice, but I'm afraid of last resort, is the official solicitor, largely because of limitation on resources. So the appointment of the official solicitor is only where there is no other suitable and willing person that can be identified to act as the litigation friend. That's all I'm going to say about the general framework, and I'm going to stop sharing and then go to Bethan, who is going to do the first part of the community care and housing and capacity to litigate in that arena. So over to you, Bethan. Thank you.
Thank you. And I hope I've got my slides there. I think I just need to backtrack. There we are. Thank you. Yes, I'm going to talk 15 minutes on issues arising in relation to medical evidence needed to establish litigation capacity, and then investigating litigation capacity and disputing that a person lacks litigation capacity. And this is with reference to housing and community care cases in particular. And we're looking at CPR 21, that's Civil Proceedings Rules Part 21, for the procedural framework around these areas. So just by way of introduction, just a few points. Civil Procedure Rules Part 21 applies, as mentioned. A range of issues can arise requiring careful navigation. Is incapacity to litigate established? Is there an objection to being assessed? Disagreements around the role of the litigation friend, disputes raised by the other party, etc. This is the subject matter of the webinar because these issues are difficult and do require careful navigation. There's useful guidance in the Law Society's document working with clients who may lack mental capacity, and there's also a very helpful document published by the Bar Council Ethics Committee, which I've mentioned at bullet point 3. At bullet point 4, I just wanted to flag something that comes up sometimes in community care cases, where a client may, for reasons that relate to their mental health condition, prefer to communicate with legal representatives, with a solicitor, specifically through a relative or a carer, but they don't actually lack litigation capacity. So they are the person who's giving the instructions in the case, but they are having little direct contact with their solicitor. And obviously, it's an important distinction between a person who has that preference for communication and lacking little litigation capacity. And also, of course, the other point that's important is that it is necessary to have some direct contact with the person themselves in those circumstances, even though they generally would like to give their instructions through another person. At point 5, I've mentioned the fact that in these areas in particular of housing and community care, there is, not infrequently, there's a link between the litigation capacity issue and the issues in the substantive issues in the case, in that what may be an issue may be the consequences for the person of their mental illness and how it affects them. And it may be for that reason that it does arise that litigation capacity can become contentious in community care and housing cases. How that then pans out in the case is it varies very much. It can really simply mean that the representatives of the client who lacks litigation capacity go and get another medical report to firm up on the litigation capacity evidence. Or it can go as far as we'll see as having a full-blown contested hearing on litigation capacity. And as I say, this talk focuses on medical evidence and on investigating and disputing litigation capacity. So first of all, with regards to medical evidence, and just picking up on Helen's introduction there are two means under CPR 21, which we're concerned with here as for our procedural framework in these areas. We're talking about judicial review or civil litigation in the county court or the high court. So we're talking about the framework that we have for under CPR 21 in these sorts of cases. And there are two ways of appointing a litigation friend. One is without a court order by filing a certificate of suitability, or by applying for a court order. And in each case, there is no actual rule that requires medical evidence, although it is envisaged that medical evidence will generally be filed. Also, it's worth noting that in both instances, there's no requirement to serve any medical opinion on the other party, although the court may direct it in relation to an application to appoint a litigation friend. There's no requirement to serve the medical evidence where certificate of suitability is being relied on. Then with regards to the form that the medical evidence takes, where it's medical evidence is being produced in order to establish the need for litigation friend, there's no specific format for medical evidence. But as Helen mentioned, quite often a certificate as to capacity to conduct proceedings is used. And I'm sure many people listening will be very familiar with this form, which is available on UK.gov. It guides the expert to provide all the information that will deal with the mental capacity test, and contains also useful guidance. So it is actually a very convenient form to download and to use in support of applying to put in place a litigation friend. Alternatively, a report from a clinician would be another format for the evidence. And I've mentioned there that the degree of detail that's needed in a letter of instruction to a clinician for a report or for completion of the certificate as to capacity, and the amount of detail that's needed in that expert's opinion will vary according to the nature of the case. Some cases will be very straightforward. Other cases may require greater explanation. And in those instances, the guidance in AMDC against AG, a Court of Protection case, paragraph 28 may be useful in directing an expert as to what to put down in the report and how to structure the report. In particular, sometimes it's very useful to record an exchange of what the person actually said when they were being assessed, in order to demonstrate their degree of understanding or lack of understanding or ability to use and weigh, etc. Is medical evidence always required to establish that, that there's a lack of capacity? So obviously the rules don't require it. Do the courts always require it? They don't always require it, but there is plenty of dicta which implies that generally they are going to need it. And Baker, Tilley and Maka is one such case where a judge in cost proceedings had determined without medical evidence that a litigant in person lacked litigation capacity because she got very distraught. She was being pursued for about £500,000 in costs. She ended up rolling on the floor in the corridor outside the courtroom and screaming. The judge determined on her presentation that she lacked litigation capacity, and that was overturned on appeal. The judge had really gone too far in concluding that she lacked capacity. As you remember from Helen's explanation at the outset, the MCA requires that there is a disturbance in the functioning of an impairment or disturbance in the functioning of the mind or brain, and that would not necessarily be indicated by the fact that the person suffered a loss of control temporarily, as she did. As I say, that was overturned. The court saying that the court should be very cautious before concluding that the person has a disturbance of the mind without medical evidence. But in Hinduja, that was a case in which the court was prepared to find that the person lacked litigation capacity without the need for medical evidence, and reference there was made to the overriding objective in that particular case. So it depends very much on the facts of the case, but in most cases, it's likely that one would need medical evidence of some kind. Then in terms of investigating suspected lack of capacity to conduct proceedings, this need to investigate arises in most cases when the solicitor meets the client, and it's the solicitor who will pick up on the need for capacity to be investigated. And there's a lot of guidance that's useful in the Law Society document I referred to in one of the earlier slides about how to deal with that sort of discussion with the client, where it may be very sensitive matter, of course, to be saying to a client that there's a concern that they may lack capacity. Where an opponent, this is the second bullet point, where an opponent of a litigant in person suspects a lack of capacity, then the Court of Appeals has said in Masterman, Lister and Brutton that it would be appropriate to bring that issue before the court. So that's where an opponent might need to alert the court about a litigant in person. And then the court itself will also raise the issue and investigate capacity and initiate an investigation of capacity where it suspects that there's no capacity, but will in all likelihood require a medical report to be produced. When can one party contest the other party's incapacity to litigate? So this is a scenario where a certificate of suitability is filed, or an application has been made and a litigation friend is to be appointed. What business is it of the other party to negate that, to stand in the way of it, and to seek to assert a different view? And Fawkes and Vasey is a strong authority on this issue, and one can see in this case that courts are very wary of satellite litigation over the issue of litigation capacity. And the starting point is essentially that litigation capacity is something between the solicitor and the client, as opposed to a concern of the other parties in the case. In this particular case, the claimant claimed damages after a road accident. It was accepted that he was incapable of managing his affairs. An application was made, supported by medical evidence, for the appointment of a litigation friend. The defendant then opposed that application. The judge ordered a trial of that matter as a preliminary issue. The claimant appealed against that order and succeeded in the appeal. And the court set out that the defendant hadn't got on the appeal decision, hadn't got a good reason for opposing the appointment, the rules on capacity aren't supposed to be creating additional litigation when there's minimal impact on the substantive issues, that there's no entitlement for the other party to put forward its own evidence, to dispute the evidence filed in support of the application to appoint the litigation friends. But there may be cases where the proposed protected party themselves may need to raise the issue. So that would be a very different sort of angle on the dispute. Or there may be cases where it's legitimate to, where there's a legitimate interest. And however, and this is the principle summarised, in a situation where the proposed protected party and the litigation friend both consent to the appointment, there's adequate evidence to support the appointment and no evidence to suggest that the application is not bona fides, the court should make the orders sought. So that's the basic starting point. Although I comment at the bottom of the page, we as housing practitioners, community care practitioners, or particular housing practitioners in the county court may have experience of cases where the court has engaged in the issue of disputed litigation capacity and has has entertained that issue as an issue in the case. Either because the court is not satisfied, and mainly in my experience it is where the court is just not fully satisfied on the evidence that's been adduced, and that evidence is relevant to other issues in the case as well. Disputes about whether the party lacks litigation capacity. What if the person said to lack litigation capacity disputes that they lack litigation capacity? This is a very important civil liberties issue, of course, because when a litigation friend is imposed on a person, obviously they can't conduct the litigation themselves in their own right. Obviously, they're still the client, but another person is going to make the decision about how the litigation is conducted. And obviously, practitioners in housing and community care will be familiar with explaining to clients the reasons why they need to be assessed, and what a litigation friend does, and a person may be very unhappy with that. And usually it's possible to deal with those concerns and that unhappiness by explanations and by dealing with the process of assessment and then of conducting the business of a litigation friend in a very sensitive way, because of course the purpose of it is to enable the person to participate in the proceedings. And so there is an Article 6 dimension to having a litigation friend. The person would be at a disadvantage without one, but at the same time, of course, the person is being deprived of being able to run things in the way that they may wish. And the legal framework overall as to the rights of the individual who is not content to be represented by a litigation friend are quite usefully considered in the case of RP against UK, a case which obviously went to the European Court of Human Rights. And the facts of it were that RP had a significant learning disability. The proceedings were care proceedings concerning her child. She was represented by the official solicitor. The court, in fact, made a care order and placed her child with foster parents. She then appealed to the Court of Appeal, alleging that there'd been a breach of Article 6, that she had capacity and the official solicitor shouldn't have been involved. She wasn't happy with the way the case had been conducted. She applied to, then she lost in the Court of Appeal. She applied to the ECHR, alleging violations of Article 6. And the court determined that she had not suffered a violation of Article 6, and held that there was no breach of Article 6, taking into account that the appointment of the official solicitor had been based on a thorough assessment of her capacity by a clinician. So obviously that's very important that that assessment is done carefully, and I think was done more than once in this instance, or was more than one report in any event. In order to safeguard her Article 6 rights, it was essential that she could challenge the appointment of the official solicitor, and she had had the opportunity to do so. She had been informed that if she was concerned about the way her case was conducted, that she could speak to her solicitor or to the official solicitor or contact a complaints officer. She also had the right at any time to apply to the court to have the official solicitor discharged, and the official solicitor would have been open to invite her to undergo a further assessment had it been clear that she was in fact asserting her capacity. And then the court went on to hold that in order for that means of challenge, which is so essential to protecting her Article 6 rights, to be effective, then she needed to know of the means of challenging the appointment and the procedure for exercising that challenge, which needed to be clearly explained to her in a language which was appropriate to her level of understanding. The court went on to hold, and I'm not dealing in detail with what the duties are of the litigation friend here, but part of this judgment deals with what the role of litigation friend is, and touches on the fact that the litigation friend can, of course, conduct the litigation in a way that is not in line with the wishes of the individual concerned, because the litigation friend will not put forward a case which is unarguable, even though, of course, a litigation friend is going to try as far as possible to reflect the wishes of the person concerned, but that may not always be the way to conduct the litigation in their best interests, and may not be arguable, may not be reasonably arguable in the sense of not meeting that very bottom line threshold of arguability. And so there may be a clash there. But it's imperative, the court held, that the individual's views are put across to the court, so the person mustn't lose their voice in the proceedings. And that has actually happened in this case, so there was no breach of Article 6. So that's a useful one, really, in really setting out the rights of the individual in the face of having a litigation friend essentially imposed. And the framework for a person to challenge the imposition of a litigation friend on them in CPR 21 is in CPR 21 Rule 7 on application, but also the court can take the initiative to investigate whether the appointment of litigation friend should continue. So I'm going to finish there. Thank you very much. And I will disappear now, or my slides will disappear, and I think we're going back to Helen. Thank you very much.
Only for a second. We're going straight over to Tim. Thank you very much for that, Bethan. And whilst Tim is getting his slides up, I'm going to turn my video myself off. Thank you, Tim.
Can you see my slides or not?
Yes, I can. But I think it's on a note presentation rather than
okay. It keeps doing it. I'll switch the.
That's it. Great, thank you.
Okay, in this part of the talk tonight, I'm going to sort of try and add on to what Bethan has already said in terms of issues that arise, particularly in community care and housing cases. Most of the community care cases that we would be looking at would be various types of proceedings under the Care Act and Children Act, and so on and so forth. And with housing, those tend to be types of possession cases or injunctions. I haven't included in this issues of capacity in respect of homelessness proceedings within Part 7 of the Housing Act 1996, because the law is that someone who lacks capacity can't apply. So that seems to be a block to that one. But what I'm going to look at in terms of topics to consider are the issues of protected parties and also protected beneficiaries. We haven't heard of those before. And really looking at what is the role of the litigation friend, for example, in these proceedings as contrasted to that, for example, in the Court of Protection, and if there is any difference at all. And the litigation friend and the risk of cost. Can the litigation friend ever be at risk of an adverse cost order in civil proceedings where costs can be awarded by the court? And I'm going to touch on very briefly something else, that some other aspects of disputes with the protected party, and what is their voice in proceedings? How are they aided in proceedings? How is their autonomy advanced? And also the distinction between adults and children in urgent cases which require urgent intervention by the court. And I'll talk briefly about anonymity orders and compromise proceedings, and how also the assessment of capacity should be continually reviewed during proceedings, because it may be the case that issues of incapacity arise during the proceedings, or that issues of incapacity improve during proceedings. So you may not have a litigation friend at the beginning, but you may need one during or on a particular issue in the litigation. Or it may be that the need for a litigation friend is removed by someone's mental state improving. So what is the role of the litigation friend? So the CPR defines what a protected party is as a party or as an intended party who lacks capacity to conduct proceedings. Also, there's a definition within the CPR of a protected beneficiary. And this is defined as a protected party who lacks capacity to manage and control any money recovered on behalf or for their benefit in the proceedings. And these terms arise as a result of the Mental Capacity Act 2005. And the reason why I've focused on that is we'll see how the role of the litigation friend will differ in respect of a protected party or protected beneficiary. Not all protected parties are also a protected beneficiary. Some protected parties are protected parties alone. And the protected beneficiary features in Rule 2111, which deals with control of money recovered for the protected party. And there's an important distinction. And what one must also think about is the CPR adopts a meaning of lack of capacity within Section 2.1 of the Mental Capacity Act. And it has been noted that the mere inability to make a decision about the conduct of proceedings is not alone sufficient to make a person a protected party. There must be a link to a disturbance in the mind or brain in an adult. A protected party must have a litigation friend to conduct proceedings on their behalf. A child, that's a person under 18, irrespective of a disorder of a mind or brain, must have a litigation friend unless the court makes an order otherwise. And it is clear that a litigation friend is required in proceedings against a child or a protected party. And it must also be remembered that with some children, they don't just litigate as a protected party as a child alone. They may also have the status of a protected party when they turn 18 if they are disabled and have a disorder of mind or brain. So there can be an overlap. Basically, one looks upon a protected party as an adult with a disorder of a mind or brain that requires a litigation friend. A child separately, irrespective of a mental disorder or of the mind or brain, must have a litigation friend, but can also become a protected party by reason of a disorder of mind or brain. So one has to be clear when one is litigating with children, when they reach 18, whether or not they become a fully functioning adult or not for the purposes of a litigation friend. So what is the precise role of a litigation friend in community care cases? So what this means is, well, what does conduct of proceedings mean? This is undefined broadly within the CPR, but must mean doing anything which is in the ordinary conduct of proceedings is required or authorised under the CPR to be done by a party in the proceedings. That is, to comply with orders and directions and so on and so forth of the court. It must include a duty to act fairly and competently to conduct proceedings, and may include a duty to attend hearings. So a litigation friend may be required to attend a hearing along with the protected party or the child. And the duty of the litigation friend is to take all measures he or she deems fit for the benefit of the child or the protected party, supplementing the lack of capacity or judgment of the child or the protected party, with a function being to guard or safeguard the interests of the child or protected party for the purposes of the litigation. So it's to supplement the lack of capacity and judgment of the protected party, to safeguard their interests. So it's a form of substituted judgment to look at safeguarding someone's interests. and the litigation friend must acquaint themselves with the nature of the action. They must do it under proper legal advice, and all steps are taken to further the interest of the child or the protected party. So that is well set out in the case of Whitehall, and that's endorsed by the case of OH versus Craven. But it's not a general power to act in the broad best interest of the protected parties on all issues of capacity. For example, if one were to be defending an injunction, the very fact that somebody lacks capacity to litigate does not mean that they lack capacity to understand the terms of an injunction, or that the litigation friend cannot necessarily always agree to surrender of a tenancy. For example, if the litigation friend is not a deputy, they may have to refer to a deputy to do that. So it's not a broad general power to act in the best interests of the protected party, but it's to really advance and protect their interests within the litigation. And expenses occurred by the litigation friend, one can see that's covered by 2112(1)(a), and that's in particular in respect of the litigation friend representing a child. And CPR 21.3 identifies when a litigation friend becomes necessary. So it's, there's clear rules identifying when a litigation friend is necessary. And as both Helen and Bethan have said, there's no requirement for a litigation friend to be a solicitor or the official solicitor. They can be a family member, or they can be a lay person, but they do have to be suitable, and that they do have to deal with the proceedings in the way that these broad definitions within the court present. Risk of cost to a litigation friend. This has been asked of me on several occasions. So when considering a litigation friend without a court order, that is when you have a litigation friend either as a deputy or someone who comes forward as a suitable person, Rule 21.4 comes into play, especially Rule 21.4 sub Rule 3. So 21.4 says the rule does not apply if the court has appointed a litigation friend, but we'll come back to that in a minute. And a deputy appointed with powers to conduct proceedings, a litigation friend can act as a litigation friend. It then goes on to say if nobody has been appointed by the court, or in the case of protected party has been appointed by a deputy as set out in paragraph 2, a person may act as litigation friend if he can fairly and competently conduct proceedings on behalf of the child or protected party, has no interest adverse to that of the child or the protected party, and importantly, C, where the child or protected party is a claimant, and this is a claimant alone, undertakes to pay the costs with which the child or the protected party may be ordered to pay in relation to the proceedings, subject to any right he may have to be repaid from the assets of the child or the protected party. So this raises the question as to what is the liability, if anything, of the litigation friend for costs. Under this rule, it is, under this rule specifically under 21.4, it applies only to a claimant's litigation friend. It does not state anything about a Part 20 claimant, that is a counterclaim, but we'll deal with that a little bit later on. And there's no general rule the litigation friend will have to pay the costs of the child or the protected party would have to pay. It's viewed as typically just to be an order for the claims litigation friends to pay the costs if such an order would have to be made against themselves if they were not a child or a protected party, but in a court exercising their discretion will take account of all the relevant circumstances. And there was a case called Glover and Barker, which identified where a litigation friend may be held liable for the costs. Basically, the basic rule is that the litigation friend pays the costs out of the either the assets of the protected party or child if they're not publicly funded, or gets the benefit of cost protection if they are legally aided, at least in the lower courts. But if, depending on the specific facts of the case, the court may make an order against litigation friend to include bad faith, improper or unreasonable behaviour, and prospect of personal benefit. And this was in respect of a company case. So it is a way that if there is a litigation friend who looks to stand to get a substantial benefit out of the case, a personal benefit, then they may have a cost order against themselves personally. So it doesn't, the litigation friend does not have absolute indemnity if they're acting contrary to the interest, for example, of the a protected party, but the rule there is to enable the litigation friend to pay adverse cost order, and that would apply also if a case went to the Court of Appeal, where the cost rules are different, even if you're legally aided, that the litigation friend would effectively be paying the other party's costs out of the legal aid fund. But that's what the rule does. Disputes and protected parties, where is the voice of protected party? And as Bethan said, in Fawkes and Vasey, for example, one of the key elements in not interfering with the appointment of a litigation friend is that there's a consent of the proposed protected party and the litigation friend to the litigation friend acting on their behalf. When I read that aspect of the case, I did find that a little bit unusual, given that the issue is in respect of the ability of the protected party to conduct litigation. So there must be at least some notional capacity that the protected party can consent to this relationship. If consent, what happens? Well, the litigation friend is generally appointed without any problem. If there is no consent to the protected party, there's a dispute. The court does enter into, I've had this where the court enters into a preliminary issues trial to work out whether or not the protected party does in fact lack capacity and does in fact, and law, require a litigation friend. Because after all, the determination of capacity is a legal issue. It's a legal issue for the court. One question that's been raised with me is whether the court can make any interim declarations as to incapacity using Part 23 of the Civil Procedure Rules, sort of an interim application pending a determination of capacity to litigate. I don't think you can, given the whole framework of Part 21, but it might be different if you're talking about a witness who lacks capacity, who doesn't accept they have that issue and have not been examined. But the question is, if appointed, if a litigation friend is appointed, how is the voice of the protected party heard at all, or if at all? How is that communicated to the court? and it's not clear, at least from the civil procedure rules, and how the court expects this to be done in housing and community care cases. Urgent proceedings, children v. adults. The rules do allow for, do permit a child to conduct proceedings without a litigation friend on an application, subject to the later desirability of a litigation friend being appointed. And here I put two things together. What if there's an urgent claim for judicial review with a child? If on the basis of some instruction with the appropriate application, an application can be made within the judicial review claim to bring the claim without having a litigation friend in place. The alternative question, however, is what happens if you have an adult? And the problem there is that if an adult is street homeless, but lacking capacity, without a litigation friend, what do you do? Because you don't have the same rule to permit you to bring a claim with permission of the court. My basic view is that if the client can at least sign a legal aid form and the solicitor determines it's in the best interest to issue an urgent judicial review with the notion of appointing a litigation friend, then that would, I think, still pass muster with the court, because otherwise a person would be left without any protection. I'm pretty much out of time, but what I've identified in the last couple of slides is what is required to compromise a damages claim. And what I've tried to identify in this is that if there are distinct rules between if you're a protected party and a protected beneficiary as how you can receive and manage money out of a claim, and also that if one looks closely at the practice direction, the very elaborate requirements for having an advice and so on and so forth as to quantum only relates to personal injury claims. So that's a compromise. I describe what the basis of anonymity applications, that's under 39(2), 3 and 4 and the conditions for it. And finally, just to say that there's a requirement to have a continued review of capacity. So I'm going to stop there.
Thanks very much, Tim. And out of time, I'm afraid you are. We're going straight to Ollie Percy. Thank you for the questions that are coming through. Hopefully we'll have time to get to them. And over to you, Ollie. Thank you.
Great. Hopefully everyone can see that. I am going to have a canter through how litigation capacity works in the fairly unusual context of the Special Educational Needs and Disability Tribunal. My first slide sets out some resources that I think you should have to hand if you're navigating these issues. So if you are a special educational needs practitioner, or you just happen to be doing one of those cases and it's adjacent to one of your core practice areas, have these points to hand and hopefully you'll be good to go. So why is the SEND Tribunal a rather unusual context for litigation capacity? Well, in the context of young people, there's an unusual provision called Regulation 64, which provides for an alternative person that displaces the young person who lacks capacity in material domains. So instead of having young person with impaired capacity as the party, the alternative person becomes the party. And the definition of an alternative person is set out at 64(2) of the SEND regulations. And representative is defined in section 80 of the Children and Families Act, which I linked to on my first slide. But a representative of the young person is either a deputy, a health and welfare deputy of the Court of Protection, or someone with a lasting power of attorney, or B, the young person's parent, where the young person does not have such a representative. And then C, there's an ancillary provision if young person's parent also lacks capacity in material domains. So the definition of alternative person has caused me practical difficulties in centre tribunal claims. I've acted where the effective carer isn't the parent, and the person bringing the appeal is not the parent. And what approach is the tribunal going to take to that? Well, in my experience, it's been a practical and effective approach, looking at the overriding objective and considerations of Article 6, Article 14. And obviously the relevant other status here is disability. And Article 6 is the right to a fair hearing as protected under the ECHR. Now, the overriding objective, as we're all familiar with, is for matters to be dealt with proportionately as possible. So in my experience, the tribunal has adopted a flexible approach to how alternative person is defined. If it's not a parent or someone formally appointed, because that would, by the Court of Protection, because that would cause delay, but the person is exercising the same functions and materially it makes no difference, my experience in practice is that the tribunal has been rather flexible. Now, as I mentioned, this is a wholesale substitution, or as the Upper Tribunal in Buckinghamshire case, which I put on my first slide, it is a statutory substitution of the party, and that has consequences. So an obvious consequence is legal aid funding. So under Regulation 18 of the merits criteria, a party whose eligibility is financial eligibility is going to be assessed is, in the ordinary sense, a party. So if you started the appeal looking at young person's means and young person was financially eligible, and then you progress the appeal and it becomes apparent that young person lacks capacity in material domains, then the party changes by a wholesale substitution, and you notify the tribunal of this via Rule 9.1 subsection B of the tribunal procedure rules, which provides for the substitution mechanism. And you can substitute back in again if the capacity changes. But it is a wholesale substitution, and it means the party changes for the purpose of the merits regulations for legal aid. And I'll speak more to that later, because I ended up working on a case where we had to threaten judicial review for to keep funding of our exceptional case funding for representation in a send appeal. So I'm going to briefly canter through this because I'm conscious of the time, but what is the function of an alternative person? What's the responsibility of an alternative person? Well, they're acting in respect of the young person, but not on behalf of the young person in the way an advocate would. Fine. That's the distinction between legal representation and litigation friend. The decision is not taken by the parent on the young person's behalf, rather it is taken by the parent in their capacity as the alternative person in the young person's best interest. So this is standard best interest assessment. So what is relatively unusual, again, about the Send Tribunal is the interaction between the statutory duties in the Children and Families Act 2014, in particular section 19. So at all stages, even though the alternative person is wholesale substituted out of proceedings, and in how they liaise with the local authority outside of the tribunal, the alternative provision extends beyond tribunal proceedings. There is a statutory duty to still look and get the views from the young person who is deemed to have impaired capacity. So the overriding objective and how that comes into play in terms of navigating litigation capacity in the Send Tribunal context. So the case of Buckinghamshire is again really helpful on this point. It may involve drawing an issue to the tribunal's attention and perhaps providing the tribunal with any evidence it needs to resolve the issue. And this is part of the overriding objective for fairly obvious reasons. You're meant to be explaining to the tribunal what the issues are and why impaired capacity is relevant to the tribunal. This analysis is concerned with the capacity to bring an appeal. If that issue arises, the most efficient way to resolve it may be as a preliminary issue that the tribunal will have to decide before it identifies the correct parties. However, that becomes slightly tricky, because when you have a preliminary hearing, that injects delay into proceedings. And if so, I've been involved with cases where we've had a preliminary hearing and that's knocked back the timetable. And you then need to square the circle about the third point I put on that slide, about cases in relation to children's education being cases where the utmost urgency is required. And there is clear authority on that. So how do you balance the two? The overriding objective, as in the leading up a tribunal case says ordinarily a preliminary hearing, versus the Court of Appeal case law, which is very clear on you need to move as quickly as possible. I think it's going to be fact and case specific, which is the classic lawyer cop-out answer. But in a case that I've done, the tribunal decided it wasn't proportionate to have a preliminary hearing because the evidence was fairly clear that our young person lacked capacity in material domains, and therefore there'd be little added from having a contested hearing on the point. So, link between subject matter capacity and litigation capacity is really important in the context of the Central Tribunal, as it is elsewhere. But effectively, if your client has capacity in material domains in relation to the subject matter, it's hard to conceive of how the tribunal appeal would actually function because it's their decision making about an education healthcare plan. If they decide they don't want something in it, the whole process of an EHCP appeal is negotiating what goes in, what goes out. And while there are some complexities to the litigation process, that is the heart of it. So if you had diverging litigation and subject matter capacity, you're going to be in real difficulty. And I've never come across a case where that's actually happened. But I'll talk to that a bit further in my summary of the issues at the end. There's a really helpful case if you're a solicitor and you think your young person might lack capacity in material domains. There's a really helpful recent COP case about what factors are relevant and what information that that a young person would need to understand, retain, use and weigh, applying the functional test under Section 3 of the Mental Capacity Act in the context of an education healthcare needs assessment. But the principles broadly transfer over to EHCPs more generally. And it's my experience that tribunal judges have found this guidance from the Court of Protection really instructive. In the interest of time, I'm not going to go through the factors in detail. They're listed on my slides and the slides will be shared. So what are the practical issues? So I mentioned already legal aid eligibility. We had to PAP the legal aid agency when they said that our party, now the alternative person, failed the means test, so no exceptional case funding if you don't pass the means test. They backed down on that after PAP, and the relevant provision that we relied upon was Regulation 15 of the legal aid means regs, which provides that if you're acting in a representative capacity and you don't benefit from proceedings, then the means must be disregarded. And they initially didn't accept that in the exceptional case funding application, but they did upon PAP. Who should undertake the capacity assessment? In my experience, it's a mixture of social workers and educational psychologists. There's an issue with local authority social workers undertaking assessment sometimes because they're also the defendant in the proceedings. And if the young person is expressing a view that might diverge from the alternative person, and the young person's view might be more favourable to the local authority's view, then there's a conflict of interest there in terms of the capacity assessment. But I'm not going to put it any higher than that. Every social worker that I've worked with has absolute integrity, but there are ultimately pressures that might be placed upon them. Obtaining views of young person is hugely important for the reasons already set out. Section 19 supplement of the Children and Families Act supplements the ordinary principles on obtaining wishes and feelings of a protected party. And the way that's normally done is by an independent advocate speaking with a young person, ideally about the contents of the education healthcare plan, if that's not possible, on a more abstract level about what they want more generally, about placement, what they want in terms of provision more generally, if you're not going into the nuts and bolts of it. How often should there be capacity assessments? Well, as already mentioned, capacity is temporal specific. So a young person's capacity could fluctuate. At one point in the proceedings, they might have capacity in material domains. In another point of the proceedings, they might not. It's really important that litigation capacity and subject matter capacity, and as I've mentioned, the two are intertwined very strongly in the centre tribunal context, are kept under constant review by solicitors, and that's the responsible thing to do. An overriding objective requires you to act proportionately and responsibly in this regard and keep the tribunal up to date. If a party raises it because the proceedings have gone on for a long period of time, then it might be proper for that issue to be revisited, but it will be a fact and case-sensitive decision about whether that happens. And as I mentioned, there are big problems. It's a real difficulty if litigation capacity and subject matter capacity diverge, and it might not be possible to continue the litigation, but you need to look at the facts of the case and explore it. And that's the end of my presentation. Thank you very much.
Thanks so much, Ollie. And straight over to you, please, Emma, for your section. Thanks very much.
Thanks, Helen. I'm just going to share my screen now. Is that all right? Can everyone see that okay?
Yeah, that's great.
Brilliant, thank you. So in the remaining time that we have this afternoon, I'm going to look at the Immigration and Asylum Tribunal. And in terms of what I'm going to cover, I'm going to look at these four issues. So first of all, general issues that come up in immigration and asylum, then flagging points that may arise in the context specifically of detention, then moving on to kind of the practical considerations for practitioners, which aligns with both what Bethan and Tim have spoke about. And then finally, to pick up on the impact that mental health and special education needs may have on the substantive issues in the immigration claim. I just wanted to begin, obviously, with a point I think that's come out of all of the practice areas that we've been discussing today, is that these are all areas where the client cohort are likely to be vulnerable, and that equally applies in the context of asylum and immigration. And some of the categories that you may find that your clients are falling into are unaccompanied asylum-seeking children, looked after children who are already in the care of the authorities here in the UK, people who are suffering from special education needs, disabilities or learning difficulties that may not have been identified yet, because often in the immigration and asylum context, late identification is a real reality. Mental health diagnoses, in particular complex post-traumatic stress disorder, major depressive disorder, anxiety disorder. And also not just because of the personal characteristics of the individual, but also the experiences that they've gone through. So if there are incidents of persecution, of trafficking, of exploitation, or indeed difficult untraumatic journeys to the UK, all of that can impact the question of capacity. And obviously the key takeaway, I think, out of all of the discussions today is early identification is key to ensuring that there's access to justice and fairness for individuals. So as practitioners, I think it's useful to always have it on the radar at the beginning of opening a client file, particularly if your client falls into any of these vulnerable categories in the immigration context. On this slide, I've just put up a number of resources that may help practitioners deal with the kind of day-to-day issues. And these are things that I usually go back to myself when I'm faced with an issue about capacity. So obviously everybody will be very familiar now with the Joint Presidential Guidance Note and the Practice Direction, which have been around for about 11 years. There's also the Equal Treatment Bench Book, which is useful to go back to if you're finding there's some resistance in the tribunal in terms of making adaptations or special measures for your client, which shouldn't be the case anymore. And there's also, as Bethan flagged earlier, the regulatory guidance notes from both the Law Society, the BSB and the Bar Ethics Committee. And then finally, I wanted to raise the really important work that Migrants Organised has been doing within the sector to try and account for the fact that in immigration and asylum, we don't have a codified procedural process for capacity, and we don't have a system for appointing litigation friends. And there's two publications from Migrants Organised you'll hear me talk about today. The first is a guide on mental capacity and litigation friends compiled by Jennifer Blair, and the second is their research findings from their long-term mental capacity project. I really wanted to just kind of stress two issues I think that come up time and time again in practice, which can be quite tricky, I think, sometimes to identify. And that's the distinction between capacity to instruct and capacity to litigate the claim and capacity to give evidence before the tribunal. Many of us will be much more familiar with the second issue because in most asylum and human rights claims, we very often have applications to have clients or witnesses treated as vulnerable witnesses, and we need to apply for adjustments to be made to the procedural process. What we're perhaps less familiar with, but which we're encountering more and more, are issues around capacity to instruct. And so when you're approaching a case, particularly I'm thinking a paradigm case of an asylum seeker, where there are concerns about mental health or cognition, for example, when you're thinking about your letter of instruction to your expert, it's important to distinguish between capacity to instruct and also capacity to give evidence. It's quite possible that you might have a client who has capacity to instruct you, capacity to understand their appeal and to make decisions about the litigation, but does not have the capacity to give oral evidence before the tribunal. And so it's just really important to make sure that if you're in that situation, that you've also covered capacity to instruct, because I think sometimes in our jurisdiction that can fall off the radar because it's not something we've had to grapple with until the last couple of years. A question I think that has already been raised in the chat, but I think it's worth touching on now, is the difference between the position and the application stage and at appeal. So obviously when you're dealing with an application, it's not appropriate to appoint a litigation friend because it's not litigation yet. So there's no system at the application stage. And it is possible, however, to apply to the Court of Protection for an order. That is it can be quite difficult to do so. And also, I think practically what the research from Migrants Organised has shown that it can be difficult to try and locate a suitable person to stand in as a deputy at that stage. The reality is, I think for many people going through the FTT in the context of statutory appeals, you may find it prudent to identify an anticipated litigation friend, whether that might be a suitable foster parent that's looking after an unaccompanied asylum-seeking child, or a potential family member where there's no conflict of interest with the appellant. But the reality is that, unfortunately, there isn't a codified system for the application stage. There are, however, availability for litigation friends at the tribunal stage, and that's been the position since C and the FTT. That was a judicial review case in 2016. Initially, the tribunal was of the view that the powers in the procedural rules did not afford them the flexibility to appoint a litigation friend. But the High Court found that that would be contrary to the principles of procedural fairness and also would prevent access to justice for a vulnerable person. So the rules need to be read in a way that permits appointments of litigation friends. And obviously the point that comes out of C, which is touched on by the Court of Appeal in the very important case of AM Afghanistan, is that we don't have an equivalent of Part 21 of the CPR in the tribunal. AM Afghanistan is obviously an important case that will be well known to many of you. It's obviously important for both the joint presidential guidance and ensuring that the tribunal follows the guidance when faced with a vulnerable witness, but also it confirms the point in C that there's ample flexibility within the rules to permit the appointment of a litigation friend. These principles are now well bedded in within the tribunal, and the tribunal is becoming more and more familiar with the need to appoint litigation friends. But I think it's just worth reflecting on what the court said at paragraph 49 of the judgment is the court itself acknowledges that it's not satisfactory that in our jurisdiction we don't have a codified position as there is in Part 21 of the CPR. And instead we have to manage things on an ad hoc basis using the wide powers of case management. There have been attempts to write to the Tribunal Procedure Committee to initiate a system for litigation friends. But as I understand from reading the minutes of the committee that are published every quarter or so, the problem to date has been resourcing and funding, unsurprisingly, of the system. So as yet, there's still no movement on an actual system for litigation friends in the Immigration Tribunal. And then finally, the other piece of case law that we have in this jurisdiction is JS, which is a judicial review case from the Upper Tribunal 2019. And it's an important case for anybody that works with children and young people in asylum and immigration appeals or judicial reviews. And in that case, the Upper Tribunal gave guidance on when they expect that a child will need a litigation friend. So Tim spoke at length about the position for children and protected parties under CPR Part 21. For those of you who conduct most of your work in that arena, this will probably seem slightly unusual in the sense that what the tribunal have done have imposed a regime based on the age of the child. So as a general principle, children who are 16 and 17 without any other attendant vulnerability will be presumed to have capacity. So the tribunal usually will not need to appoint a litigation friend, even if they are not legally represented. As somebody that works with young children who are 16, 17, and sometimes where there have been historic issues with legal representation, my experience is I would be cautious about accepting at face value that any child of 16 does have capacity. And I think it's important as representatives to make sure that we've properly interrogated all of the circumstances. And if we do have concerns, we still should seek medical expert evidence on the point. You can see, however, that the tribunal also expects a graduated response for children aged between 12 and 15. And it sets out a number of considerations. Are they legally represented? Is there a parent involved? Is the local authority involved? Do they have any other kind of vulnerability? And then finally, children under 12 will normally require a litigation friend. It's worth saying that I think that has probably come from the fact that the tribunal has other case law on evidence that says that children under 12 normally will not be expected to give oral evidence because the tribunal's of the view that it's unlikely to be assisted by evidence from a child that young. So I think just to flag, JS is the applicable guidance from the tribunal that remains in force. But I think in terms of discharging our own professional obligations when working with children who are all age up to 17, 18, I think we still need to be mindful of the specific question for that specific young person about whether or not they do in fact have capacity. In addition to the appeals and judicial review context, I just wanted to flag that capacity can arise where you're representing detained clients as well. So if you have a client through the detained surgery, or you have a client that you're representing in their unlawful detention claim, mental capacity may well be an issue that's relevant to that as well. On the next couple of slides, I've set out in some detail the findings of the Court of Appeal in two cases, VC and ASK and NDA, both of which are detention cases where the court found that the Home Office did not have in place any system to assist vulnerable detainees, and that there was no availability or any mechanism for them to be able to put representations to the Home Office about the suitability of detention, to understand decisions that were being made in the context of their immigration claim. And so unsurprisingly, the Court of Appeal found that that was unlawful, and there was a lacuna in the policy framework on the detention side. The Home Office has tried to remedy that through the publication of a detention services order, which came out last year. The DSO, as I'm aware, has not been litigated on yet as to whether or not it is in fact an adequate safeguard for people who lack mental capacity. So that question, I think, is still up for grabs. But in terms of applicability now, I just wanted to flag into the steps that are imposed upon the Home Office include, as you can see here, paragraphs 22 and 23, that the Home Office has to identify whether or not a person may possibly lack capacity and take necessary steps to ensure that the person has access to legal representation and that any necessary reasonable adjustments are made to accommodate this or to facilitate any daily living issues experienced by the individuals. And that's obviously going to be most crucial, I think, in the context of urgent removals, charter flights, certification of appeal rights, and continued detention. So in those cases, if you are faced with someone who you think there are doubts about their capacity, one of the issues you should be pushing back on the Home Office and seeking disclosure of is what steps have they taken to meet their duties under the DSO. And then I think finally, just to move on to kind of the practical issues for practitioners in the tribunal, in the context of both statutory appeals and judicial review in the upper tribunal, in terms of how you actually practically go about appointing a litigation friend, you need to make an application to the tribunal. As I said, there is no equivalent of Part 21 of the CPR, so you will need to make an application in writing, but there's no prescribed form. In terms of the evidence, going back to what the other speakers have said, and it's been my experience that you do usually need to support the application for a litigation friend with medical evidence at the time, or at least indicate when it's going to be forthcoming. And it's important to remember that the litigation friend will be making considerable decisions about a person's rights, and the tribunal approaches it from that perspective to make sure that it's safeguarding the appellant's rights. So you can expect the tribunal possibly to scrutinise the quality of the medical evidence, whether the expert has addressed the issues properly, whether they've been provided with all the relevant documents, the case history, etc. Because these are more complex issues and often they require applications and often submissions at case management, it's a good idea to instruct counsel early, particularly if you are concerned about whether or not your client does or does not have capacity. Typically, it's dealt with as a preliminary issue at the case management stage. You may have a small hearing with the judge on this particular issue. But I haven't had the Home Office yet dispute mental capacity, but I know that it does happen from time to time. And I think the points that were made earlier, I think it was Tim's presentation about the role of opponents is a relevant one. And then finally, just to be aware that although the CPR doesn't apply, it's worth having the litigation friend sign the certificate of suitability, because judges expect that will be provided, even though it's not strictly required by the tribunal. Obviously, the position is different in the administrative court if you're issuing on a nationality JR, a trafficking JR, or an unlawful detention JR. That procedure, as has been said by both Bethan and Tim, is codified in Part 21. Obviously, the position is different for children because it's presumed all children under 18 should have a litigation friend. But the point that Tim made about children reaching their 18th birthday is still a good one, and about whether or not you need additional medical evidence about their capacity where there's any doubt. And again, just flagging what's been said, obviously early application is advisable and supported by evidence. And then finally, I just wanted to briefly touch on suitable litigation friends. It has to be someone who's willing to undertake the role. They have to be able to act fairly and competently. If there is no suitable litigation friend, potentially official solicitor, but again, has been emphasised, this is only as a last resort. And there is unfortunately no system in the tribunal. Migrants Organised have done exceptional work in terms of setting up an advocates project. And I've given you the reference there to their report and their contact. And then finally, just briefly, if you've an issue about capacity or mental health or disability in your procedural claim, how does that affect the substantive case? We've already touched on the fact that you need to be alive to the giving of evidence and whether there needs to be reasonable adjustments, or if it's appropriate for your client to give evidence at all. In the context of refugee claims, it can bite on the question of whether or not they are a particular social group, as is recognised in DH. It goes to questions about risk on return. So you have persecution on grounds of mental illness or disability, persecutory discrimination. Are they going to be more susceptible to exploitation or trafficking? Do you have issues in terms of a child's right to access education, particularly if there are special education needs? And obviously then it also bites on human rights claims as well. So is the standard of care in the proposed country of return non-human rights compliant? So is it chaining, or is it cultural practices that are actually contrary to human rights norms? We have the typical health claims from AM Zimbabwe, and also discriminatory denial of treatment. And it's also worth, I think, just being mindful of, at the end of the process, your client has been given a period of leave, whether or not you need to be making representations for indefinite leave to remain based on mental incapacity. So if there are long-term issues with capacity, is this really a case where a person needs to be settled in the UK rather than have a short period of discretionary leave or 5 years grant of asylum? So those are all the points I wanted to make in terms of the immigration issues. I'm going to stop sharing my screen now.
Thanks so much, Emma. And just following on, we may go a little bit over 6:30, but just following on from your practical tips, one of the questions is, how would you deal with the evidence giving of the protected party? I know you touched on this in the distinction. For example, preparation and signing of a witness statement based on instructions with the prospect of oral evidence. Oh,
just on mute. If I mean, typically I have found that if a client lacks capacity to instruct, most of the experts have also said they've lacked capacity to give an account in the tribunal, and that's because the same kinds of processes about weighing up information, evaluating the question, are also affected by whatever has impaired their capacity to instruct their solicitor. So typically, if I had a client that couldn't instruct me, I wouldn't put them forward as a witness in the tribunal. And in those circumstances, I wouldn't file a witness statement from them either, because I wouldn't be confident that we could rely upon what is said. And what is helpful is in AM Afghanistan, the Court of Appeal indicate that what the tribunal should be doing is looking at the objective evidence in those circumstances, and that's how you give voice to the person in the proceeding. So if they've given an account to the psychiatrist or the educational psychologist, if that's buttressed by CAM's notes or by what the school have said, that will be a sufficient factual basis for the judge to make findings. And then we should be saying to the judge, you have their limited instructions or account, but this is what the country expert says will happen to them on return. And so in that way, there is an element of participation, but you're also protecting the fact that they aren't able to put forward reliable instructions. Mm-hmm. So that would be kind of the approach I would take in immigration.
Great. Thanks for that, Emma. Just before turning to anyone else, there's a couple of procedural questions. If I could just ask Bethan, you touched on the fact that the medical evidence didn't need to be served on the other party. We've had a question here about whether or not the application needs to be served on the other party and whether or not there's a need for the certificate of suitability when applying to the court. I think a few of us have now mentioned the certificate of suitability, but in terms of serving the application on the other party, can you help, Bethan?
Yes, so the application, strictly speaking, doesn't have to be served on the other party because of the definition of respondent in the rules is the person against whom the application is brought, and the application to appoint litigation friend is not brought against the other party, but the court can direct that it is served on the other party, and it may well do so. And of course, it could be served on the other party, even though there's no requirement. Obviously, it has to be filed at court. The certificate of suitability has to be filed at court. The medical evidence supporting it doesn't have to be served. The certificate of suitability should be served, but the medical evidence doesn't have to be served. Sometimes it is, but there isn't a requirement for it to be served. In terms of when you make an application to court, you don't have to provide a certificate of suitability, but you have to provide evidence. So you have to provide essentially the same information by way of evidence in support of the application as goes in the certificate of suitability, which is showing essentially that you are a person who is appropriate to take on the task, i.e. no interest adverse to the protected party or the child, can fairly competently conduct the proceedings, etc. So it's the same in substance. Hope that answers the question.
Thanks, Bethan. And just over to you, Ollie, just on what's the position of the alternative person? There's a question here from Patrick. I'm sorry, I'm not naming all the people who are asking questions because not all of their names are coming up or they're disappearing. But Ollie, are you able to help on this question?
I can have a go. It's quite a tricky question, to be honest.
Do you want to read it out, just so that everyone has seen it?
What is the position if the alternative person AP under the Children and Families Act 2014, so going back to section 80 and then regulation 64 Descend Code of Practice of Descend regulations, does not appear to be acting appropriately for the young person's interest, e.g. AP wants to cease EHC plan, but young person wants to go to college. Is that a tribunal issue or a court protection issue? Well, in practice, that's not going to get its way in front of the tribunal, because if alternative person wants to cease to maintain, and a local authority isn't going to, in my experience, is not going to fight hard to try and maintain an expensive education, health and care plan. So that issue might not actually reach the tribunal. If they are appointed by the Court of Protection, then that might be an issue of going to the OPG, because they're potentially misusing their powers and not acting in the best interests. If it went to the tribunal, for example, the local authority takes the view that it's not a cease to maintain, or maybe it's a more balanced inappropriate position taken by the alternative person, and it's something that would end up in the tribunal but is obviously not in their best interest. For example, they're looking for a type of placement that would be utterly unsuitable. I think the tribunal would be minded to exercise its discretion within to make findings to that effect. I've had cases where there have been allegations of bad faith against the alternative person, and the tribunal has been, although it didn't find sufficient evidence in one of the cases that I was instructed in, it made it clear that if it had done so, it would have acted accordingly and potentially made an order substituting the party for another alternative person if there had been one. If there's not another alternative person, you do rather fall into difficulty. So again, the tribunal's hand might be tied, and it might end up back in the Court of Protection to try and find another someone who falls within the criteria of alternative person as a representative. So it's a little bit tricky. It really depends on the facts. But
okay, well,
that's my go at answering that question.
Well done. Thanks very much for that, Ollie. And I should say, in respect of all of these answers that are being given, they're not constituting legal advice. They're answering questions without us knowing any of the facts behind the question or the substance of it. So please take care. These are questions that are being answered, as it were, in a bit of a vacuum. There's several questions about the beginning of proceedings. Before we get to them, a question with either Tim or Bethan you want to have a go at. It's from Srimila, who says, if during the proceedings one of the defendants are found to lack capacity, what points would the court consider in order to decide whether the proceedings should be overturned or the case should proceed from the current place?
Should I go first on this one?
Sure.
Well, what the civil procedure rules say at 21.3 rule 3, it says if during proceedings a party lacks capacity to continue to conduct proceedings, no party may take any further step in the proceedings without the permission of the court until the protected party has a litigation friend. But it also says for any step taken before the child or protected party has a litigation friend has no effect unless the court orders otherwise. So there would be two. What I understand here is that one of the defendants lacks capacity. Once that is found out, no further steps could be taken in respect to the proceedings, I would say at all, until a litigation friend is appointed. But that doesn't necessarily mean that previous steps would automatically be set aside and they'd have to restart. It would very much, I think, depend precisely on the nature of the proceedings. So it can continue. It just can continue with a litigation friend, because it may have been that beforehand, unless there was evidence that the defendant had previous historic capacity issues, then it's from that point. So that's how the rules deal with it. So it's someone becoming incapacitated during the proceedings.
Thanks, Tim. Anything you want to add on that, Bethan, or should we go to, no? We'll go on to the next one then. So some of the issues at the beginning of proceedings are obviously quite challenging, looking at some of the questions where there isn't, perhaps a client hasn't got capacity to engage initially to provide instructions, or they'd struggle with a capacity assessment. What's a person to do? I've put somewhere in response to one of the questions, the Law Society guidance on dealing with clients or potential clients who may lack mental capacity, and that's available on the internet. I can copy that into the chat again. Not sure how I did it last time, but I can try and do it again. But that's the Law Society guidance note. There's also mention of where there's no suitable family member or friend. This is early on at the outset of the case, and nobody close to the potential client to help. And this person's experience as the official solicitor is not keen to get involved that early on. How to proceed? Difficult one, because that's quite right. The official solicitor won't be keen to get involved at that very early stage. I don't know if anyone has any tips on that. My sense is that Emma, you mentioned about other organisations that are closely aligned to a particular client group. There may be avenues there where people can offer support and help to prospective clients prior to at least making the decision whether or not there is a cause of action or a claim or something like that that needs to be taken forward. I don't know if there's anything that anyone wants to add to that. Tim, you've unmuted yourself. That's
I think there are two things. One, the solicitor has to look back at the SRA rules or whatever they are, and what their ultimate duty is to the client. Because I recollect reading something that they're under an obligation in any event to act in their client's best interests, which may require them taking certain steps in respect of assisting them, even if they lack capacity and don't have a litigation friend at that stage. The alternative approach is at that stage, you could reach out to certain organisations, because it's not clear to me at that point. It's saying initial instructions or a capacity assessment. The person doesn't have to have capacity to engage in a capacity assessment. One can be done without them even being present. So it's tricky. I mean, there are various organisations they can approach, such as Mind, various local or advocacy organisations that will have what they call paid litigation friends who can assist. I mean, I know in South Wales there are organisations that have where the local authority puts by a fund to pay litigation friends in the absence of other things. But ultimately, it's really whether the solicitor, how the solicitor acts in the client's best interest. If they don't have anybody who is willing to act as a litigation friend, that's the fundamental duty. And the solicitor themselves would have a duty to assess, at least for the purposes of accepting instructions, whether they could actually accept instructions, without a litigation friend. So it's a tricky one. I think that the starting point is to look at the code of conduct, look at any other local resources like Mind, age concern, any local provision in the absence of a family member or the official solicitor.
Thanks, Tim. This may be one for you, Emma. I'm not sure. I'm very conscious of the time. We're not able to stay all evening, I'm afraid, to answer these questions, but just perhaps one or two more. But this is in relation to, again, at the beginning of proceedings where there's a 6-month limitation date on discrimination claims, not enough time to get clear medical evidence before the deadline. Practice tips on how to proceed if you're close to the deadline and these vulnerable clients have got severe mental ill health. There's a pressure on resources at the moment, as we know, nationally. And so trying to extract from heavily pressurized services, these kinds of assessments can be a real challenge. I know in the Court of Protection, getting medical assessments now, psychiatric assessments, they're giving time estimates of 16 weeks. So it's a real problem. I don't know, Emma, if you've got any ideas of how to get around that or do something to protect the client's position?
I mean, I had this in the start of COVID in an unlawful detention judicial review where we thought capacity might be an issue. And so but also the point you made, Helen, about it simply wasn't possible to get a face-to-face assessment at the very beginning because doctors couldn't go into the detention centre because they were on lockdown. So we flagged it with the court and we asked for directions so that we could stay the claim but protect the client's interests in terms of damages. And then we also tried to urgently find someone that could go in. And we managed to get, I think in that case, we got a telephone or a Skype assessment done in the interim, which wasn't ideal because obviously we want face-to-face. But I think if you are worried, I think what I would do is, and there's a deadline, I'd be minded to put the court on notice that you're worried about capacity as an issue, that you're taking steps to find an expert or undertake an assessment and seek directions or a stay whilst that's resolved. And then at least you've been seen to act, I think, in the client's best interest. And also you've been responsible with the court, I think, by putting on record that this is a genuine issue and it's crossed your radar.
Thanks very much, Emma. There's a question here from Anita Williams. Evidential question, really. It's a housing case. I don't know if Bethan or Tim want to have a look at this, where there's a concern about the capacity of the tenant to conduct the proceedings. If the first step to be taken is an application to the court, what's the status of any behavioural warning letters that were sent previously? And there's an appreciation in the question. This obviously crosses in across the Equality Act and the Public Sector Equality Duty in terms of how the tenant's been dealt with. But in terms of the evidence, is it clear what the status of prior warning letters would be if subsequently there's a finding that the tenant lacks capacity to conduct proceedings?
I've had something like this. Well, prior warning letters, it would be really, because they themselves are not litigation, they don't count, I think, as litigation for the purposes of at least Part 21 of the Civil Procedure Rules, because it says, if one looks at 21.3, the stage of proceedings at which litigation friend becomes necessary, a person may not, without permission of the court, make an application or take any step except issuing and serving a claim or applying for an appointment of a litigation friend. So you could always issue a claim against an incapacitated person, the issue then becomes, well, the notices and these warning letters then become part of the litigation, because it would be whether that person could be assessed as being able to comply with the term, with the notice, say, or the warning letters. And really, it would probably depend on an assessment within the litigation as to their ability to comply with those warning letters or whatever. The court of itself does not have any power, I think, off the top of my head, to set aside notices or warning letters within the context of litigation. It doesn't generally have the power to quash steps, but it would be something that would be dealt with within the context of the litigation, because, you know, whether the court would make a possession order against somebody who didn't have the capacity to comply with a warning letter, you know, and that prompted the claim for possession. And it may be that you need other proceedings to deal with that, like the court of protection or something ancillary.
Right, thanks, Tim. I'm afraid I've put in the link, but it's failed to work in the chat. I'm conscious that it's 10 to 7, and I'm afraid unless the people who are looking at me are saying they're happy to stay, that I may need to wrap it up, I'm afraid. Sorry to those whose questions that we didn't get. Oh, Bethan, you're going to speak.
Yeah, well, thank you, Helen, and I appreciate we do have to wrap up, obviously. I just happened to notice one question which I thought raised a really important point, and it just might be perhaps a point to end on, maybe, which Please. Was the need when representing a person, there's litigation friends who reflect their values and their wishes and feelings. You know, I couldn't agree more. It's not actually written down in case law as far as I can see, but I think this is an area which is going to get more attention because of the United Nations Convention on the Rights of People with Disabilities, and just generally more attention on what is the right way to represent somebody who formally lacks litigation capacity. It arises, of course, in the best interest tests in the Court of Protection as well, the weight that needs to be attached to a person's wishes and feelings. Of course, we have loads of constraints on us, legal aid, what's reasonably arguable, what just makes sense. But the need to try to hone in on what the person wants is really absolutely vital when major things are at stake, and to argue things that you know, perhaps a little bit at the margins at times. If we can, I mean, we have a sort of plethora of duties, but I think this is an area that needs a bit more attention, and it comes up as quite a tricky one sometimes when you're deciding which way a case should go.
Thanks very much for that, Bethan, and bringing the protected party back to the centre of this particular webinar. Thanks to everyone for attending. Thanks to Bethan, Tim, Ollie and Emma for all their contributions, and have a very good evening. Thank you.